Good afternoon again, ladies and gentlemen. Thank you very much indeed for your prompt return. We've got an interesting session lined up this afternoon, which is about the alert mechanism. And that's what Martin Frone from the Commission spoke about earlier this morning. He spoke about it being a balance between mobility and protection, and that it's a proactive warning to all member states through the IMIS, Internal Market Information System. So let's hear what our panel and you have to say about it as well, because as before, the European Commission is listening to your input about how well you think things are working and how they could be improved. Let's introduce the panel. At the very far end, we have Geraldine Kelly, Assistant Principal from the Department of Health in Ireland. And next to Geraldine, we have Marek Szrawinski, Polish Chamber of Physicians and Dentists. Next, we have Tatiana Melchevich, National Coordinator for the Recognition of Professional Qualifications at the Ministry of Higher Education and Science in Denmark. And then next, we have Nicola Weil. And Nicola, if I can find her position very quickly, and I do have it here, Nicola is convener at the Health Professionals Crossing Borders, HPCB, and Sarada Das, closest to me, Deputy Secretary General from the Standing Committee of European Doctors. So let's begin with the alert mechanism, which is meant to share information on registered professionals who have been restricted in working, for example, where there might be a patient safety risk or risk to a minor. And this alerts the other member states and consequently is meant to prevent a professional deemed unsuitable in one member state from working in another. We're going to set the scene first with Geraldine and Nicola, but Geraldine first to tell us about Ireland's experience and what triggers an alert. How do you deal with an incoming alert and what happens?
Okay, hello everybody. I'm just going to speak very briefly on, in terms of outgoing alerts, what triggers an alert in Ireland, incoming alert, how we deal with them. Then just give a case study of the experience of one of our competent authorities in using the alert mechanism. And finally, just some feedback from our overall competent authorities. First of all, Ireland is a small country and we're quite centralised, so I think it was possibly easier to provide training to the relevant competent authorities than in some of the larger countries. We have a population of, I think, 4.7 million. In terms of what triggers an alert, the alert provides for the conveyance of the information if there's a restriction or prohibition on practice. And we had regard to recital 29 of the Modernising Directive, which states that a specific alert mechanism is necessary for health professions under Directive 2005/36/EC. All member states shall be alerted if a professional is no longer entitled due to a disciplinary action or criminal conviction. So we have limited our notifications under the alert mechanism to persons who have been prohibited or restricted in practice arising from a disciplinary action or a criminal conviction. Then just to describe very briefly a typical fitness to practice process in Ireland. If a complaint is received about a professional, if the regulator has an immediate concern about patient safety, it may go immediately to the High Court to seek the imposition of an interim suspension on the person. And in that case, they are restricted in their practice and the alert issues within 3 days. If there is not perceived to be an immediate patient safety, public safety risk, the complaint would go through our usual fitness to practice process, which can take some time, and there's 4 different stages in it. First, the complaint goes to what's called a preliminary proceedings committee, which decides is there actually a complaint or not. If they decide there is, then it goes to the Fitness to Practice Committee, which holds a hearing into the issue. And if substantiates the complaint, then it goes on to the council or board of the individual regulator, and its role is to decide on the sanction. And then the 4th tier, that sanction doesn't become effective until the High Court actually confirms it. And there are various sanctions that are provided for in our health regulatory acts, and some will lead to the issue of an alert because they prohibit or restrict practice, and others don't. So the ones that lead to the issue of an alert are where conditions are attached to a person's registration, where a registration is suspended, where there's cancellation of registration, or where they're prohibited on applying for restoration for a specific period. So if that's the sanction that's imposed, then the alert will issue within 3 days. If the sanction is merely advice, admonishment or censure or a fine, an alert does not issue because their practice has not been restricted. Then just to give an overview of the situation in Ireland, we have issued 18 alerts in relation to medical practitioners, 27 alerts in relation to nurses, and 6 alerts in relation to other health professions. And just move on to a case study is of the Nursing and Midwifery Board of Ireland. It is competent authority for both nurses and midwives, and it has 65,000 registrants approximately. And the nationality of the registrants' qualification varies. There's 41,000 from Ireland, 13,000 from the United Kingdom, and within the EEA space there's just under 3,000, 650 from Poland, 430 from Romania, 350 from Spain, 260 from Portugal, and the other EEAs just under 900. And then we've quite a lot of third country practitioners as well, nearly 8,500. When they have to, in dealing with the alerts, they have to deal with both the nurse module and the other health profession module, because midwives do not have a separate module. So it has to date identified 8 persons who are of interest to it, who are subject to an alert. 7 were on its register already, and 1 person was seeking qualification recognition. But just an example of the workload. To the end of March, there were 7,439 alerts for nurses and 2,965 for other health professions. And the NMBI claims it takes them 5 to 7 minutes on average to check both the individual alert, to open it up and read it, and to see if the name is on their own register. So if just doing some simple arithmetic, that means it's taken them 867 hours to identify 8 persons of interest. So I think that just gives a sort of an idea of the volume of alerts that we're dealing with, and versus and yet while it improves our information, but it is it's quite onerous on competent authorities. Thank you.
Geraldine, when you look at these alerts, how come they get triggered? Who's doing the triggering? What is the suspicion about what has happened? Is it more falsifying documents, or is it the fact that somebody actually is deemed unsuitable to practice? Do we know how that divides?
Yeah, well, I think the Commission has some statistics, and there have only actually been 2 alerts issued in the case of falsified documents. So there have been 13,500 alerts issued in total till the end of March. So only 2. And I think that's because, certainly in Ireland, if we discovered that documents were fraudulent, we would not proceed with the application. But to have to go to court and have the fraudulent activity proved in court would just be another admin burden.
Mm. Okay, all right. We're going to look at the triggering alert, the procedure and the sanctions in just a moment, and I want to open it up to the floor and have your views coming forth on that. But first, let me bring in Nicola Weil. Nicola Weil is from the Health Professionals Crossing Borders. Nicola, now the UK has triggered the vast majority of alerts to date. Can we work out why that might be?
So just to clarify, I'm here speaking for the HPCB network, and we held a conference at the end of last year and followed this up with a survey of the various European healthcare competence authorities, because we wanted to try and find out what they were thinking about the alert mechanism, raising the issues that are of concern or ideas to improve it. And I have to admit that one of the main things that people said to us in the survey was, what on earth is happening in the UK? Why are there so many alerts being sent from the UK? And I think when we looked into it and when we spoke to the various competent authorities in the UK, The directive itself is pretty clear that any restriction to practice of a professional must result in an alert. And because there is such a disparity between the different national legal and regulatory systems across Europe, it just appears that some countries make use of restrictions more than others. From what we saw and when we looked into the alerts that were being sent, it ticked the boxes of the directive. You know, it was a fitness to practice or a criminal sanction. It wasn't just for administrative reasons. And the professional had been restricted to practice. So that's something that was really picked up when authorities spoke to us and completed our kind of internal survey. That firstly, they said the alert mechanism is good. It's a great patient safety tool, you know, positive feedback in that respect. But that there's a disparity across Europe in the different legal and regulatory systems, and that results in different countries using the alert, sometimes in completely different ways.
So is that a problem, or is that life?
Well, I think it's life. I mean, there's a whole issue of subsidiarity, and I don't think the Commission would even try to institute, you know, a whole European-wide system of regulation. And I mean, that's just opening a massive can of worms. But then it is also a problem, and a lot of the feedback we received from smaller competent authorities in some of the smaller member states was that they simply didn't have the resources to spend, like Geraldine said, 5 to 7 minutes per alert if you're getting through, you know, 7,000. And so the danger is that a professional who genuinely could pose a danger to patients will slip through the net because they'll be lost in the mass of all of the alerts.
So it's not necessarily a matter of, say, the UK being overzealous. It's just simply a matter of how the rules are stated and how each country interprets those rules.
Yeah, and how then in turn each country has their legal and regulatory system. So, for example, in particular in the UK competent authorities in general don't issue a fine, whereas other countries may issue a fine, but that doesn't result in a restriction to practice, so it wouldn't result in an alert. So I think the very different national rules, and this was picked up in our survey, so many different national rules in play that authorities found it quite difficult to know, you know, to translate what the alerts meant.
So the background on how somebody practiced within a particular country might trigger an alert in another country, but doesn't in another.
Yes,
Okay,
exactly.
all right. So let's look at this at the moment about the number of alerts and them being triggered, and whether the way that it is working, with some countries being very, very concerned about the sheer volume of alerts, is that throwing up problems? Questions? Yes? Heinrich? Anybody else? We can get the microphone too. This is now's your chance. Microphone, please. Thank you. There, blue shirt. Thank you.
Geraldine says it lasts about 857 hours for all these 30,000 alerts. Do you think it is worth to bring in that power? Is it worth?
We need to know if somebody has been prohibited or restricted from practice. So it's information that we do need to know. Now, it's just that it's taking quite an amount of time to actually interrogate and use the alert mechanism to find that information. In the case of the nursing board, whose example I used, it happens that all the cases were actually from the United Kingdom.
That's what I thought about. That's all from the UK, and they are no problem for the Irish system, I think, that 8 cases.
Well, we would still have to deal with those cases, and say in nursing they happen to have been from the United Kingdom, and we actually have national legislation which provides for the transfer of information between the United Kingdom and Ireland already. But say, for example, our medical council they have identified about 30 people of interest, and some were from Lithuania, where the alert is issued if the person doesn't renew their licence. But the reason why they haven't renewed their licence is because they have moved to Ireland to practice medicine. So there is, when our medical council have actually gone behind the alert, there is no need to take any national action.
So does the European Union have to set out a list of what is allowed to trigger an alert? Do you think that there needs to be more discrepancy or more rules about how to trigger an alert or what constitutes an alert, Nicola?
Definitely from the results of the survey that we did of healthcare competent authorities, that was one of the main kind of the key flashpoints, that there should be some kind of guidance to enable people just to have the consistency across the system.
Heinrich?
It would be helpful if 90% of the alerts we can forget. We have only 10%, and then we have not 800, but 80 hours for dealing with the alerts. But I think it's always the problem for especially Germany that we have, I think, 50 authorities surround Germany. We have no central register for that. Nurses, for physiotherapists, for teachers, no way. So each of the 50 authority has to take care 80 hours, and that's for me, it's too much. It can't function. So I suggest my authority, when they have not the time and they won't look at all of these 13,000 or 1,300 alerts, they have to use it when there is a new application for a new nurse. And that's for me the importance of the alert mechanism as a register where I can look at in it when I have a new application for a new nurse or something else.
What do you think about that, Nicola?
I totally understand the point, and you're not the only authority who told us that. A number of authorities from across Europe said that's exactly how they use the alert mechanism. But then the danger is that just duplicates the system of certificates of good standing, which is, what you check when the nurse or the doctor or the physiotherapist registers for applies to register anyway. So it's not providing any added value. Also, it doesn't pick up the cases which we hear about a lot, where a professional is registered in 2 countries at the same time. So you've already had their application, they're on your register, so if you don't check, you would never know. But I definitely understand the concern.
Any more points from the floor on this as well? You want to pop your hand up? I wanted to ask about the countries then that don't seem to trigger very many alert mechanisms. Are they missing something important then, do you think, Nicola?
Well, if they don't send out the alerts themselves, I mean, that's purely down to their national systems, whether it's, we hear sort of legal requirements are higher, the burden of proof is higher. They're not necessarily missing out, but it just demonstrates the different systems in place across the EU.
Thank you. Any views from the floor? Yes, there's a hand going up there. Yeah, microphone, please. Thank you. Anybody? And another one there. That's great too. 1, 2, and then 3 afterwards. Great. Go ahead.
This is Sadie Sari from the Dutch Competent Authority. I think Geraldine's problem and our problem would be solved by a simple technical solution. If it was possible to export the alerts so we can technically compare them with our own register, it would save us a lot of time to compare them one by one by clicking all of the alerts in the IMI system. So I would suggest the possibility to export a file of alerts of a certain period.
What about that? Do you think that would work, Geraldine?
Yeah, I think certainly we would support that idea. Yeah, it's you have to physically open up each alert. My ministry acts as competent authority for certain professions at the moment directly, so we have that same problem. You have to open each alert before you find out the name of the person. So that I think would improve matters.
Nicola, do you see a downside to that, or is that sensible?
Well, I don't want to put words in the European Commission's mouth, but the main downside I think that would be mentioned would be data protection. Personally, that's
and we have to have strong data protection on this. There is no question of that.
Yeah, but it is done within the data protection legislation, and the competent authority should only open it if they have use for it within the data protection requirements. So it should, it should respect data protection legislation.
Okay, let's see. View from down there, please. Sorry, can't hear you. Just speak again.
My name is Lieselotte Marnef. I'm from the Flemish Government Ministry of Education. I was actually wondering what your opinion would be on, for instance, cases where the profession is not just linked, or when the practitioner is not just linked to one profession. Let's say we have cases where there's somebody trained as a nurse working in education, and so this, I mean, we're now thinking in boxes, so to say, but in practice it's not. There are often cases who can be in 2 or maybe 3 boxes, so what to do with these kind of cases?
Yes, employment conditions according to professions are not just very simple in the way that they're categorised. Nicola, do you want to have a quick word about that?
Well, just to say that was raised when we did our HPCB survey as well. A number of competent authorities mentioned that, and I think their view was that because the alert mechanism is based on modules, and you don't necessarily, if you have access to a certain module, say the doctor module, you may not then have access to the nurses, so you would miss those kind of cases. But it was something that was raised as well, yeah.
But that is a difficult one, isn't it? I mean, how do you check out somebody who is, say, a school nurse? I mean, do they have to get professional recognition through being a nurse, or being employed in school, or both? And do those overlap? How does that work in practice?
In terms of the alert mechanism for that, I mean, I don't know. I could only speak on behalf of the nursing regulators, that they would be registered with the nursing regulator. But I don't know if something came through on the education of minors module where the nursing regulators would have view of that. I don't think they would necessarily.
Okay. View from down there.
Good afternoon. My name is Cedric for the European Federation of Dental Regulators and Competent Authorities. I have one statement and one question. The statement regards the fact that I can indeed testify that among our members, the competent authorities, the readiness to use the alert mechanism is very different from one member state to another one. And I second the view expressed by Nicola that indeed guidelines or a code of practice or whatever the name is, but a document to help the competent authorities for implement the alert mechanism is really needed across Europe. And then the question, it regards a feedback I have from members, which are, they request, if it is possible, more filters in the appearance of the alert, of the email. I understand that IMI system is done at the EU level, and then there is, let's say, the use or the implementation that is done at the national level. That is very clear. Nevertheless, in the upfront of the alert, apparently it would be useful if it could be already categorized professions by professions, and then it would be a kind of technical reply to the small competent authorities with limited human resources, and it would help them to manage the number of alerts they receive. The question then would be rather addressed to the European Commission rather than to the panel.
Thank you. Yes, the Commissioner taking notes. Don't worry about that. Any thoughts that anybody else wants to raise at this point? Okay, we're going to move to what happens when the alert mechanism is triggered. I'm turning to Tatiana for this. I want to know how far in the EPC application process are the alerts appearing, what happens, what procedures are followed, what are the consequences, that sort of thing.
Thank you. Good afternoon, everybody. I hope I find you well after the lunch for this issue. One thing is for sure, you can't, when you trigger the alert mechanism, you can't shut the whole thing down and go away. That's the only one certain thing that it never will take place. But it depends it depends a little bit of what kind of application we are dealing with. Is it the ordinary application for recognition, or a person is already established or providing services in another member state, or there is a question of European professional card? Because when we are talking about European professional card, the procedure is maybe a little bit more sensitive and requires from the competent authorities to be alert in a different way, because they are obliged by the number of rules, both in the regulation and in the directive, how to approach this situation. So partly it will also depend on what type of European professional card and the stage of the professional card we are talking about. If we are talking about an ordinary declaration professional card that is to be issued by the home member state, then it is that member state, home member state, that holds the case a little bit longer in its own hands than if you have the professional card that is already issued in the host member state, meaning in the cases of provision of services that are under the control of the Article 7.4 or the establishment cases. But the rules that applies daily, that are adopted, are quite clear and requires, firstly, that the competent authority, in a timely manner, like it is written in the text, update the IMI file. And that is the first thing that is quite important. And here it comes again, the question of mutual trust and who is winning, who is losing by using the alert system regularly. So that is one very, very, very important thing. Maybe it's also important to emphasize that when you trigger the alert, you can't just close the European professional card. You have to update IMI file, and you have also take to the consideration what type of sanctions took place. And in very severe, very extreme situations, it might be the European professional card that might be withdrawn. If you are the member state, home member state, that is on a way to issue the professional card for the citizen from your country, and then the alert triggers, then you have another both technical and legal problem. When the person is withdrawn right to exercise the profession, then that person has a lot of difficulties to provide the evidence of legal establishment, which is the information in the IMI system that is required. So a lot of things are on the shoulders of the home member states, you may say. In those severe cases, I assume that it will be possible for the home member states, a competent authority, not to go further with professional card. If you have the nurse that killed 5 patients, it is rather different situations than the person that you have that didn't pay a fee. So it's not the main rule or the horizontal rule. You always do one and the same thing. It will depend on from case to case, because the sanctions are different, the causes for sanctions are different. In the other hand, when you have the professional card that is issued and is, how should you call it, in possession of another member state, because you as a home member state have validated the verified documents and sent it, but there is another country that has issued the professional card, it's extremely important for that member state to know whether there is an alert that took place in another member state, because it might have some consequences in that member state. But home member state will not be able to withdraw verify the document. The only thing that is possible to be done, both technically and legally, is to update this IMI file, so the host member state is informed about the change in the legal status of the person that moved and has probably got professional recognition and is in a possession of the professional card. So that is why I said you can't just shut the whole thing down and go home. It's not so straight away. And for that reason, I think it's very, very crucial that all member states, competent authorities in particular, are conscious and aware of importance of this cooperation, and that cooperation that is timely cooperation. We are aware of the same problem. We have partly problems with UK, but I will not frame you today.
We'll come on to cooperation
I will not.
and trust.
No.
Tatiana, we'll come on to cooperation
Yes.
and trust a little bit later.
Yeah.
I'm interested in this triggering the mechanism, and how when you trigger the mechanism, you get caught up into a procedure that you can't get out of very easily. That's what comes across. I want to know whether you think that the way that the mechanism is triggered is fair and that it works, and how it could be improved. So if you have views about that, it would be very interesting to hear them now about triggering the mechanism and that aspect of things. Yep. Thank you. Anybody else? Yes, gentleman there as well. Another microphone over there. Great, thank you.
I have a suggestion for a part of alerts that might not be the majority of alerts, but still, as far as we are concerned, this might be a data protection problem, or at least issue. So there is also an alert triggered when persons, professionals relinquish their approbation or their license, which might not always or might never mean that any criminal suspicion has been brought up against them. So if there could be just in the system technically be added some, I don't know, box to check or whatever to make clear that this professional has just given up their license, so they are not object or subject to suspicions in any way, because we have to inform them, and when we inform them, they can actually sue us for for the alert that we have established, and there can be quite a lot of misunderstandings. So we have had calls from professionals saying, "Why on earth has there been an alert against me?"
I see. So because the case is never dropped, in effect, the black mark goes against somebody's name all along, even if there may be a very good reason for that trigger to be started.
Well, in the case that someone who's aged, 65, and they simply have given up their practice and they don't need their license anymore, then in order to avoid paying fees, they just give up the license, but they still are object to alerts, and that is what are the facts that the situation that I'm talking about.
Okay, thank you. Another view was over here, wasn't it? Yes, there we are.
Yes, Pierre Degonde talking for the French Order of Physiotherapists. Just regarding the time for triggering the alert, we have a little problem that we have, as competent authority, we have to wait the notification from the court who has made a final ruling to trigger the alert as competent authority. And because of the overwhelming volume of decision and rulings within the national courts, it takes some time to have this notification from the courts and then to trigger the alert in the alert mechanism. And as a home state competent authority, we also want to point out that we have some difficulties to have some information from other member states, because as competent authority, we require, under French law, an extract from the criminal record. And in many cases, the request the authority made to other member states is never answered, or we cannot have the actual document we required. And so that it is a problem to then give the authorization to practice.
Okay, I got that. A quick comment about that, Tatiana? Or something, sorry.
Yes. Can I ask you if you have my presentation just to put...
Yes, we have your presentation,
yes,
so everything's ready. Yes.
Only the one that is sanctions that lead to the alert. It should give the part of the answer. It has never been intention from the directive, regulation, European Union's policy to send the alert to any person that is retired doctor, retired nurse. It is simply not the purpose of the alert system. If you look closely to Recital 29 in the directive, for example, you will then read about what is the purpose, is to improve the safety of patients and prohibit people that committed the crime or that got withdrawn their license to practice because of the reasons that have something with patients' safety, or that have the protection with the children, or somebody that falsified diplomas. So it has to be something that is actually that leads to alert. That's why it is alert. It's not an ordinary information system about the legal status of every single professional. We will drown in the alert system if we do that way. So if it's happened, it is simply mistake. It's not what alert system is about. So if you have the medical doctor, 65 years old, that retired, he simply retired, his authorization doesn't exist anymore. If that person in some cases decide to move to another country and start to practice the profession, the whole process has to start from the very beginning. The person has to provide evidence that he is full qualified to exercise the same profession. He needs to have authorization. He needs to have the certificate of current professional development. He has to need the CCPD. He needs a lot of things that comes prior to alert system. So the system of alert system is made for people that made mistakes. Somehow, mistakes, crime, fraud, that what is actually written quite clear in the directive. I put, could it be the next one?
Yes, you just press the,
Yes.
I think Geraldine has it.
Oh, thank
There
you.
we are.
Yes. This is, I gave you here the short list of what triggers the alert in Denmark. If you look closely to what is written here, here you have all abnormal situations. You don't have ordinary doctors, nurses, veterinary surgeons or teachers. You have people that had committed something that triggered prohibition to work, or they got restricted access to the labor market and to exercise their profession. So that I hope this will give the clear reply to the question.
Okay, let me just remind everybody,
Yeah.
hashtag professional card is the Twitter link. I'm sure there's some coming up on this as we're talking, so keep an eye on that if you want. You want to speak a bit more about this alert mechanism and the triggering of it?
Not necessarily,
No, okay.
no.
Okay, that's fine. I'm going to
can
move
go-
on then.
you
I'm
can
going to
move
move on.
further.
I want to move on to trust and cooperation because we've already touched on it a bit this morning. Maybe there's some good reasons to mistrust certain countries or individuals or systems or whatever it is. But we need to have good trust and cooperation for this alert mechanism to work as much as possible. I'm very keen on views from the floor on this. So if you have got any thoughts about this that you want to raise, do please already. Tatiana, I know, oh, yeah, there we are, gentleman there, and then I'll go to you, Tatiana, because I know you want to talk about this too. And lady in the middle. Another microphone here, please. Thank you.
Okay, thank you. I apologize about that, but it's a question referring to the former point, if you allow me. My name is Cédric Grolot for the European Federation of Dental Regulators and Competent Authorities, and it was a question addressed to the representative of the HPCB. HPCB conducted a very interesting survey on the use of the alert mechanism across Europe, and it mapping the different sanctions that are used by the competent authorities. Sanctions for the suspending the professional activity, and sanction related to the restriction of the activity. And that kind of sanction is not spread in all the countries of Europe. I wanted to ask to Nicola if she has in mind the countries that use that kind of sanction in addition that the UK itself.
Nicola?
It was really interesting, the results of the survey, like you say, when we tried to map what the sanctions are, but also what they were imposed for. And one of the main issues that we found, one of the main disparities between countries, were those countries that would only issue a sanction if the healthcare professional did something wrong in their working life. So they harmed, an actual patient whilst they were at work. And those countries that would issue a sanction if the professional did something wrong in their entire lives. So, for example, domestic violence or drink driving or, tax fraud or something that wasn't related to their professional life. In about 50% of the countries, only focused on professional life. The other 50% took professional life and private life. And again, it was interesting in terms of the types of sanctions. And I think I've said it's about the different regulatory and legal systems across Europe, but I think maybe also culture, different kind of cultural norms come into play as well. An offence that's serious in one country is maybe not deemed as serious in another country. And the survey that we did, we couldn't really pull out kind of specifics of this country's good or this country's bad. It was really just an interesting general overview. And in a way, it maybe confirmed what competent authorities have always known or always believed for what they've learned through experience about their counterparts across Europe.
Thank you. Lady in the black.
Yes, My name is Susanne Hertz from the Danish Patient Safety Authority. And we have some problem when we receive an alert and we want to hear the background for sanction. We can't send such a request in IMI. We have to send a mail or do something. And that's one problem. The other problem is when we send such a request, there isn't a deadline for answer. So perhaps we never get an answer, and that's a lack in the system.
Okay, the Commissioner noting this. Deadline for an answer and further information you want to be available through IMI.
That we can send the request in IMI. We can't do that today.
Okay. It's being noted at the front. Okay. Any more thoughts? Yes, lady at the back. Another one again. Thank you.
Yeah, I would like to second what the lady before me just said. These are the technical difficulties that we are dealing with when it comes to alerts, specifically because it's not possible to pose a request right out of the module of the alert, but also sometimes it seemed to me that not the same authorities are registered for the module of the EPC or for simple requests and for the alert as well, so that it's not even possible to do it via the other modules. And then what follows is, even if, which has already been vastly discussed, you receive then more detailed information, which is very good as such, then you might not be able to read it. So again, there the language problem comes into play. So at this point, maybe also it would be helpful if decisions, or at least summaries of decisions, could somehow be translated in the system or made comprehensible. Because so far we've reached stuff from the UK which we can read, but then when it comes to other countries, it will be difficult.
Okay, thank you very much indeed for that. I'm going to bring in our other two panellists that we haven't heard from. We have got Marek Szywiński, legal advisor at the Polish Chamber of Physicians and Dentists in Poland, and Sarada Das, who's Deputy Secretary General, the Standing Committee of European Doctors. Marek, first of all, I want to know how active alerts are dealt with in Poland, and also any comments that you feel that you want to add to what's gone on.
Okay, thank you very much. Very interesting conference and exchange of views on the EPC for me, although we don't deal with the EPC and especially now with the alert. I will just show you some slides, introduction slides, so that you see how we deal with that in Poland regarding the two professions, medical doctors and dental practitioners, certainly two important and quite mobile professions. Just like nurses, for example, which we heard of about Ireland. In Poland, the professional self-government, which is organized in chambers and which on behalf of the state is the regulatory authority, is dealing with the alerts. As far as the incoming alerts are concerned, for medical doctors who have their own module, the Supreme Chamber, which represents the whole profession, the whole self-government on national and international levels, we receive all the incoming alerts in this module as coordinator. As coordinator, unfortunately, we have no instant access to personal data, so we have to add ourselves as a recipient of this. So this will be one of my remarks at the end. When we get the full content, the personal data, then we can check in our central register whether this concerns a doctor who is or maybe was in the past authorized to practice in Poland as well, was registered in one of the regional chambers. In case we find that the doctor is indeed registered in Poland, we forward this alert to the relevant regional chamber by adding this chamber as an additional recipient of the alert. So here again, as was already said about nurses' experiences in Ireland, it takes quite a lot of workload to identify all those persons. I will give you just some figures in a moment. As regards the regional chambers, they don't receive all alerts. They only receive those alerts that we forward to them because they concern their current or former member. So the regional chambers do not have to do all this work in Poland. And when they receive such an alert, then they take relevant actions. As you see, this is highlighted here, and it has not even 1 but 3 question marks, because we have a problem with that. What relevant actions can and should be taken by us? I will come back to that in a moment. As regards dental practitioners, because we associate 2 professions and we represent and regulate 2 professions, both medical doctors and dental practitioners, the incoming alerts are dealt with a bit differently, because dental practitioners do not have their own module. They are in the so-called other health professions module. So here the Ministry of Health acts as a coordinator. When they see that the alert, they don't have the access to personal data, but they don't need it here, because if they see that this concerns a dental practitioner, they add the Supreme Chamber as a recipient. We already have the personal data. We have the personal data, so we check the dentist. If he's registered or was registered, we forward it to the relevant regional chamber, but we do not forward it directly, as with the doctors. We, as a recipient, cannot add another recipient. So we have to call our colleagues from the ministry or send an email and kindly ask them that please add the chamber in Warsaw or the chamber in Poznań as a recipient, because this is their member. Yes, so this is...
Do you feel confident with the alert system, the way it works?
I mean, yeah, we feel confident. We know that if the alert is sent, that it means that some decision has been taken in another country. We've already talked about what should be, what decisions should trigger an alert. Here we have some doubts about it. This was already expressed. I always also take a look at the recital 29, which is a good justification of the goal of the whole alert mechanism. We see that the goal is consumer health protection. We find that the grounds should be disciplinary action or criminal conviction. So we know that sometimes it is not the case. Sometimes these are just purely administrative reasons, or someone is retired, or so on. So this makes the amount of the work too much for us, and we would like that all the competent authorities really take a look at these objectives of the alert mechanism once again, and maybe change their interpretation and do not send some alerts. Perhaps the Commission could make some paper, some guidance on this as well, as it sometimes happens with legal interpretations, because this workload is really too much. If I can show you, we've identified until now 59 alerts sent from abroad that regard doctors and dentists altogether. 59 were sent from Poland. 29 incoming alerts concerned Polish doctor or dentist, person registered in Poland. Unsurprisingly, they were all sent by the UK. And these 29 alerts concern 20 professionals, 15 doctors, 5 dental practitioners. So also the workload to identify this number of people is a bit too much for us as well. We think that there should be less alerts because high number of them is irrelevant for us.
Okay, it comes back to that uniformity of what can trigger an alert. Okay, I'll pick up with you again in a moment, Marek, but first, Sarada, I know that you don't use IMI, but you are concerned about people being able to practice cross-border.
Yes. Well, maybe, I mean, the Commission invited us at the beginning of the day to also say nice things when there are nice things to say, and I'm happy to confirm that actually our members are favorable towards the alert mechanism. We were very favorable towards it during the negotiations and supported it. And I think overall there is the impression that it is a useful tool and a useful addition to the way that competent authorities can interact with each other. Obviously, we have heard today that there are a number of problems in the actual implementation or the let's say more technical side of the tool. I think from our point of view, from CPME point of view, it's really in terms of facilitating or not hindering cross-border mobility. Well, we think that the important thing is was already said, is really that safe mobility is ensured. So on the one hand, that means that this tool is used. On the other hand, it means that it's used in a way where its purpose is still met. So as was said, if it creates sort of an alert fatigue and people start not reacting to alerts as is intended just because of the workload of it, for example, that is something that is not intended. On the other hand also, and that was something which we also highlighted a lot during negotiations, is that obviously for the professional itself, it is important that data protection is safeguarded, that principles such as presumption of innocence are safeguarded. And from our point of view, in our ideal world, it would have been more about final decisions of disciplinary actions or criminal proceedings that are communicated through the alert. We realize that the text of the directive offers some scope where it's really more driven by the national practices around managing licenses. But we hope that, well, with some tweaking, let's say, of the system, that the spirit of the alert can be safeguarded.
Okay, Marek, you want to pick up again where this leads and so on, and I'm also interested in any views from the floor. So if you want to put your hand up, by all means, I'll get the microphones ready for you. Okay, Marek.
Yeah, if I may just, these are called conclusions. We're not coming to conclusions yet, but a few points that we have from our experiences. So one thing we've already discussed, yeah, we believe that the alerts should only be related to those circumstances that have or may have implication on patient safety, not things like late payments of fees or things like that, or retirement. We have one remark regarding the fact that there are situations where a number of alerts regards the same professional and the same event that happened. Yeah, alert is broadcasted, then it's closed, and then immediately there is another alert because, for example, interim sanction has been extended or turned into a final sanction. So this may create some confusion. Perhaps there could be some history of the alerts if it regards the same person and is based on the same situation. Yes, and three very technical remarks. The coordinator, if is entitled, should have direct access to personal data without further clicking in the system. Should have a possibility to add another recipient, perhaps with a justification why we do it. And this is this is strictly related to medical doctors. Sometimes medical doctors have more than one specialty, and I was informed that you can only indicate one specialty, which may be misleading sometimes. And the last thing, we haven't discussed it, but it should be discussed as well. What are the consequences of the alert on national level? We receive it, we take 860 hours of work to identify 8 nurses in Ireland, but then what are the consequences? Yeah? Do we take these sanctions automatically? I have doubts about it. We know that in the UK, for example, among those 15 medical doctors from Poland, 3 or 4 cases were connected to language impairment. So people didn't speak English good enough. Certainly not a reason to impose suspensions or any restrictions on this person in Poland, yes, or any other country. So this is also probably an issue more for the domestic law, because the Commission gives us a tool for sharing information, but maybe this should also be an issue for EU law. What, in fact, can we do with those alerts under our national legislations? Because a person concerned by an alert will do everything to challenge another decision in his home country or another country where he is also established.
Okay, we've got 3 areas that I see that we have got time to explore. One is about the trust and cooperation, which I mentioned a few minutes ago. The second is about sanctions. And the third, you just said it, and it's just slipped from my mind. I'll remember in a moment. Sorry, I beg your pardon. Trust and cooperation, first of all. Any thoughts about that? Because that's what we're really trying to build up here in order to make things move fast and to make sure that everything falls into place and works. What about the fact that the UK triggers so many alerts? What problems does that cause? If, when you start to explore these things further, is it cleared up fast? Is it cleared up willingly? Do they get resolved? Any thoughts about that? What about sanctions? Do you think the sanctions are too severe that can be implemented? What about the process of introducing sanctions?
Cédric Rollo for the European Federation of Dental Regulators. Not a direct answer, but maybe food for thought. First of all, maybe the answer would be at the national level and not at the European level, and for the following reason. At least for the lawyer, within the code of practice, within the code of deontology, and if I take my country in France, even though you breach the code of practice in country B, this automatically lead to a breach of the code of conduct in the host country, meaning that as a professional, you have to abide with the code of conduct wherever you work in Europe. And when you breach, again, such a code of conduct in whatever country, it is per se an infringement to your own hosting code of conduct. So it really means that it is a national answer. I'm not sure it has to be harmonized in all Europe, but it would mean that the code of conduct is not limited to one country, but the professional has a deontology that would apply anywhere. The consequence of that would be that if there was a sanction in country A, it would almost automatically lead to a sanction also enlarged or applied in country B either.
Okay. Marek, any thoughts?
Well, sorry, yeah. Well, I can agree partly, but certainly there are cases where it doesn't work so well. As for example, this impaired language, yes. I mean, the person is not able to practice, is suspended in another country, but this is no ground for us to suspend this person in our country, even though there were decisions and final decisions in other countries. Certainly in cases
but
of...
isn't that the point, that actually this alert mechanism is the tool by which any one state can decide that somebody is unsuitable to practice for whatever reason, and then that stands throughout? That's no?
No, I think every country should have a power to decide on their own, within their own jurisdiction, yeah, because there are cases, I think, if we talk about the UK, which triggers so many alerts, then we have to ask ourselves, why is it happening? So is it because that professionals who work in the UK are generally less professional than others? Or is it because the approach of the British regulators is a bit different than regulators in other countries? So I guess this is the approach of the regulator. So perhaps some of the British decisions, sanctions, would not be taken in our countries if the same thing happened in Poland or elsewhere. So this automatic taking over of decisions does not always work, is not always just.
Geraldine?
Yeah, no, I just wanted to reinforce that the alert mechanism is to convey the information, and it's a matter for the member state receiving the information to decide what to do with that information. And because of, I suppose, a common travel area between the UK and Ireland, we would have had a lot of movement of professionals between the two countries. But we have had case law where our medical council wanted to strike somebody off who had been struck off in the UK, and it went to our Supreme Court, which ruled that that person was entitled to question their witnesses and that we had to rerun the entire fitness to practice process. And in this particular case, the registrant had been, there'd been 2 civil cases and a disciplinary process, and the witnesses just didn't want to travel. So we are in the process of amending our national regulatory legislation to provide that we can accept the document from the court and the disciplinary process as to what happened, and we would then decide what sanction we need to impose. And I just fully support Marek, and it is a member state competence, and his example about language, which is a relatively new language testing, came in 2005, and there was question marks about it previously. It's an example of where somebody may not have a problem with practicing in their home member state. And I think I'd just like to support it's very important that we do get the official documents and that there is a mechanism within the IMI that those court documents can be transferred to another member state if we are to use them in our own disciplinary process.
Okay. Sarada, any thoughts about what you've heard?
I would very much share the opinion. I think we have to differentiate between process at national level to sanction professionals and what the alert mechanism is. So indeed, it provides an infrastructure, and also it provides, let's say, an upgrade to a process that was already possible before the 2013 amendments. So I mean, it was already possible for competent authorities to exchange information. This was really just to create a better system of doing it, and that is also why I think that the national competent authorities' approaches to deontology and codes of practice have to stand for themselves, and that this idea of kind of having a European alert is not something I think that is compatible with the legal framework or with the intention of the alert mechanism. I think that, well, we've heard very many interesting contributions today of just really small technical tweaks that could really improve the use of the mechanism, and these ideas are like filtering alerts or creating different categories of alerts, let's say where there is a really grave patient safety issue, where there is more of an administrative issue, are things that could be possibly very beneficial to the everyday use. I think in general, we talked about trust and cooperation. I think that this is really a key point, which has also been repeated several times today, that where there are channels of communication between competent authorities, maybe issues such as the lack of responses or delayed responses also become easier to be resolved, and know that the medical competent authorities have really tried to create a kind of a network of communication and of dialogue that is also probably very useful in improving kind of everyday cooperation. So I think that these kinds of exchanges are also very important, just as much as technical changes to IMI, to really make the tools work the way we want to, so that there is safer mobility.
Okay, thank you. Tatiana, any thoughts?
I can follow the same thoughts that already have been given. On the bottom line, this trustful cooperation and systematic cooperation, it's the fundament of existence of the alert system. When I'm thinking about the alert system in practice, everyday life, I don't use it everyday life, but I'm in contact with our competent authorities that are partly frustrated by those alerts that has in the background not paid fee, and they understand very well that the legal system in one member state doesn't mean that it needs to fit in the Danish context. But on the other hand, when there are so many, there is a certain fear that by reading so many unimportant alerts, you will miss to read the one that is crucial. And that is on the bottom line of what is feedback from our competent authorities. I don't have reply on that. I can look in our colleagues from the Commission thinking about improving IMI system with possibility to filter this particular part of alerts, because I can see both in the medical professions and the teaching professions, the most of alerts are of that type. So it's not the random 2, 3, 4 alerts. It's a huge number of alerts, and if they are indicated to be the group of alerts that only concerns fee, then it will be actually the big step for the competent authorities in another member states that doesn't consider the fee or missing right to exercise professions because of the fee like that. Another thing is that the sanctions regarding administrative reasons that are in IMI system they identify like other reasons. It could be a number of other reasons that are actually very important. Another thing that again has a little bit with, not a little bit, but with the possibility to extend the IMI. This is a happy day that we are talking actually about the possibility to extend IMI, because this is first now we have experience enough to be able to talk about it. We've been actually negotiating directive in the hope of that we will find out by all those examples that will come by the time. Now we have those examples, so we can do something, that there is a ground to talk about it. Possibility for the competent authorities in the member states to get in the direct and very quick and easy contact about to another member state regarding the content of the sanction. If I was competent authority, I will dream about a little box in the IMI when I was opened the alert system where I can write or send a short message without using another model in the IMI system that is for the general exchange of information or sending email and so on and so on. We have very smart system in the IMI system indicating when the timeline is come to get reply. So something like that will help competent authorities to be aware of that they need to send reply to other countries, and it will also give a kind of security. So that is the technical aspect of improving a possibility to this safe exchange of information and alert system. Another part is, again, everybody needs to use it. It's in Danish context, it's very easy. We don't understand that it can be a high minority of member states not using the alert system. Nobody can have any interest whatsoever to have moving doctor that goes around and kill patients. Pharmacist that is problematic person for selling narcotics together with the running pharmacy. There is simply no reasoning in that. So I will encourage my colleagues, coordinators, within the modest power they have to try to promote the importance of the alert system, so we all can get some benefits of that.
Okay, all right. Let's take more questions from the floor, more thoughts about sanctions, or thoughts about trust and cooperation, or thoughts about looking ahead to what technical improvements you would like to see being made to the alert mechanism. Are there suggestions that the panel has made that make you think, yes, that's a good idea? Even if you just simply raise your hand to support it and say just as much, that would be useful. Microphone there. Are the current modules easy to manage? What do you make of the IMI and the way that you want it to work? They're all listening in the front row. They're all writing down notes. Now is your time to be able to get it changed and to modify it so that it improves.
Yes, Jurian Luiten from the Dutch Ministry of Health. I wanted to say something about the sanctions, dealing with the alerts. In the Netherlands, we have a system where we automatically take over the foreign restriction. However, there is a clause, and the migrant, the professional, has to call in this clause. And this means that if the behavior which led to the foreign restriction, if in the Netherlands it didn't lead to a restriction, then the foreign restriction is not taken over. So it's actually quite a practical and simple system, because then the Netherlands doesn't have to prove or ask for the foreign ruling,
yes,
but the migrant has to come up with the proof. So then you don't have this problem that you cannot get the information. And secondly, I think the example about the language, so the restriction that someone didn't speak the English language in the UK, it's not about the language, it's about communication with the patients and communication with colleagues. And this is something which is necessary out of the quality and patient safety. So it's not about that in Poland you need to speak English. It's about you have to communicate. And if you practice and you cannot communicate, that's something which in Poland also you have to be able to communicate. So it's about that, not about the language.
Okay. Marek, any thoughts about the whole of what was said there?
Well, certainly, this option that you sort of change the burden of proof. Yes, you don't have to prove the professional that he did something for which he should be restricted in Holland, but he has to prove that what he did abroad would not constitute something bad in the Netherlands and would not lead to any sanctions or restrictions at least. This certainly is a useful and it is a good way forward. However, this still requires some proceedings, and this person will probably call witnesses or provide some documents and so on and so on. So still we are faced with some difficult proceedings, like calling witnesses from abroad, and they don't like to go there. If they don't want to come from the UK to Ireland to be heard, then they will not come even longer distances. So this is a solution, but still not for every situation, I guess, because probably there is no solution that would serve all kind of circumstances that we may have in such cases. But this is something to think of, I guess.
Microphone back, yeah. Go ahead.
Yes, until now we have this procedure for some time, and we had some legal procedures, and well, there were not big problems. There were not problems with witnesses or anything. The basis is also, I think, that within the European Union, all the legal procedures, it's about the mutual trust, actually. I mean, I think you can trust from other member states that the legal procedures there are all right, and you don't have to do it over the whole procedure over with all witnesses.
Thank you. Lady in the middle, with the microphone, please. Pass down, thank you. Anybody else? Whilst we're turning the corner into the last 5-10 minutes or so. So this is your chance to say what you think about the alert mechanism, or draw people's attention to other points of view with it.
Yes, I can supply that we have the same legislation in Denmark as in the Netherlands. Then we take over the sanction abroad and take it over, and we don't investigate the case. We trust the foreign state that they have done their job well. So yes. And our decision can't be appealed. It can be proved by a judge, but it can't be appealed.
Okay, thank you very much indeed. More questions from the floor? Anybody? Oh yeah, sorry, Geraldine. Sorry,
I said we were amending our national legislation, and we are having a similar approach to the Netherlands, where we would shift the burden of proof. It's up to the registrant to disprove the case that has been proved in the other member state. But I think we would certainly have appeals of decisions. So it will be up to the registrant to disprove the case, and we would then decide the sanction. And that would still rest with the national authority. So if some process has to be gone through, but it's a much reduced process.
Okay.
But I'm surprised given the importance of the right to livelihood that there isn't an appeal process of decisions. Thanks.
That was the other thing, actually. Appeals was the third thing on my list. Any thoughts about appeals? No, not at the moment. Okay. I want to turn to the panel to sum up. And when they sum up, I want them to think very much about what works with the alert mechanism. That's good. That works very well. And secondly, what would you improve about it from perhaps a technical point of view, or whatever, however you see it. Nicola.
So speaking on behalf of HPCB and the views that were submitted to us, the most important thing to say is that in general, competent authorities like the alert. They do see that it's a useful tool, it's good for patient safety, it's a positive step forward. But like's been mentioned here, there are some issues and technical improvements, operationality, some of the things that have already been mentioned, such as getting further information on the content of an alert. If there could just be a button on IMI, yes, tick, I request further information, that could be straight away sent to the sender of the alert. guidance from the Commission on when alerts should be sent, when they shouldn't be sent, how long authorities would have to respond if further information is requested, that would be great. And then also, in a vain attempt to try and reduce some of the alerts being sent, could there be things we could do operationally? So one of the ideas that we received was, could there be an edit function on an alert? As Merrick mentioned, sometimes a number of alerts are sent for the same professional for the same procedure. Because at the moment, if a sanction changes, the alert has to be closed and then reopened, and then it may change again, so it's closed and reopened, but it's the same professional and the same procedure. Maybe if we could just go in and update the existing alert. And then the final kind of gripe that competent authorities mentioned to us was the 3-day deadline, which is quite tight. However, that's enshrined in the directive. So, there's nothing that can be done about that.
We cannot make legal changes, but we can make technical changes.
Exactly.
That's the thought behind it. Okay, summing up, Geraldine.
Yeah, no, I think our competent authorities welcome the alert mechanism. There is the issue with the volume of alerts. I'm just looking at some Commission statistics here, and the UK has 68% of the alerts are issued by the UK. Now, some of them probably relate to the same individual. So if there was some mechanism to edit alerts, that might reduce the volume somewhat. I think that, we need to be clear that it's about information exchange, and it's still a member state competence to provide for disciplinary sanction. It certainly shines a light on variation in the member states. It can't be that, health professionals in the UK are underperforming. So what is it actually saying about other member states?
Okay, Marek.
I think that most important issues have been raised already, and we have some requests to the Commission to take into consideration, also technical things regarding the system, which may help us with the whole workload. Then, of course, in some countries we still have some legislative work to do about the follow-up to the alerts. Yes, and of course the alert mechanism as such is an important tool, and it is easier to get information now than it was before.
So it falls on the more positive side than the negative side by far. Okay. Tatiana, your view of just closing up now?
Yes, the positive sides are huge comparing to not having alert system, and if anybody remembers how it was before the alert system, now we are in the different age completely. What I can see the potential to improvement is basically improvement of contact between competent authorities in member states on two levels. The one to mobilize member states that are not mobilized yet, and improving possibility to exchange the information about the sanctions that are given. I listened very carefully to the colleague from Holland talking about the taking the sanctions from another member state, and we have the same system in Denmark, but on the other side of the story is the citizens. We have to remember that rules are for the citizens. Citizens are not for the rules. It has to be served in the proper way, and it means basically when you have the information that is correct and in timely manner sent, then you can actually make your you can estimate whether you actually need to withdraw the access to exercise the profession, and will that sanction you give, is it justified and is it proportionate in the context of your member state? I can't see why should the doctor from not speaking English will not get access to exercise profession as a doctor in Denmark, because he can't work in Denmark without Danish language, which is quite important. So, but the basic line is actually, I think the improvement between the contact between competent authorities in member states will also lead us and give some further steps to better understanding, and also the application of national legislation regarding the sanctions.
Okay, thank you. Sarada, if you had one request of the Commission in improving this, what would it be?
I think to keep up the commitment to improving these tools. So from a technical point of view, I think this sort of event is very useful, and I think that looking at the better implementation of what already exists is always a good place to start.
Thank you very much indeed. Thank you very much, panel, for all your contributions. It's been very helpful looking at the alert mechanism. And listening to it in the front row is Andras Sigmund. And Andras spoke earlier on. He was the one that gave you the feedback on the survey that he'd had. And so this is more information for him about how the alert mechanism was working, and obviously the EPC when we looked at that earlier on in the day. So Andras, if you'd like to come up and just give us a quick summary of the main points that you have taken from what has been said today and how important it is to you from that point. Yep, you can come up here. Yep, take that microphone and just come up beside me. That's great. Because there are lots of things that people have raised from the floor and on the panels, and they're interested to know what in particular struck you as being very important and worth following up.
Thank you very much, Diana. I will start first focusing on this last panel, which was on the alert mechanism. Thank you very much for all the panelists for the interesting input and also for your questions. I wanted to go back to one issue which was mentioned many times about the guidance on what kind of sanctions should trigger an alert and what kind of guidance the Commission could provide. And on this point, I think we are obviously open to provide any kind of legal guidance, but I'm afraid the guidance would basically stop on the moment when we explain of what is the purpose of the alert mechanism and what was the reasoning behind. We wouldn't be able to go down to national level and explain that member state A would have to send an alert on the basis of this and this and these national sanctions and not on the other. So we are very happy to basically provide or again explanation on what is the aim, what is the objective of the alert mechanism. But on the other hand, each national competent authority has to do its homework, has to actually map its national sanctions and decide on the basis that what is the one which triggers an alert. It's important to mention that we realize this issue absolutely, and it is on our radar. And we have an exercise within our group of coordinators, and maybe Tatiana or Geraldine could comment on this, because they were also very kindly presenting in this exercise. In this exercise, what we do is that we ask member states to present actually how is their national rules are working as regards the professional rules or as regards also ethical rules. And we ask them to also explain what are the sanctions which they consider as triggering an alert. And we saw that these discussions helped quite a lot to make the recipient side understand that what kind of national decisions could be behind the alerts, and they can also treat these alerts accordingly better and give them importance when it is necessary, or give them less importance when it is not. We realized from the survey that this is not always arriving on the competent authority level, so this is something which we take into account, and we will see how could we better formulate on a position paper or maybe a non-paper level that to make sure that it actually is available for the competent authorities. But we are committed to continue this kind of, let's say, informal discussions. But any other thoughts what you could provide is very useful for us. What I have to state and what I can state on behalf of my unit is that we don't have any intention to harmonize professional rules in the member state. As it was stated many times, this is a national subsidiarity issue, and we will have to find a way to work among the different national settings. Another point I wanted to raise is that indeed the idea of the alert mechanism is to provide warning. So it is a mechanism to provide information to each other quickly. And if we look at this situation, this can be very interesting if we balance on one hand the data protection issue and the other hand what is necessary to know by the authorities. It's always important to keep in mind that the alert mechanism is not focusing only on professionals who have mobility issues. It can be, for example, a doctor who is living in the very far end of Hungary, who never wanted to move to another member state, committed something wrong in Hungary, got prohibited, and then all the 27 member states were informed about this doctor. So that's the reason why the alert mechanism, the alerts itself are containing a very limited information only. This is basically a warning for the others to get in contact with, in this example, the Hungarian authorities and ask for more information if necessary. Zoli will talk more about the developments which makes this communication easier, but we have to bear in mind that in the alert itself, we have to somehow limit the information that we share with each other, because this information goes immediately to all the member states. And the last point I wanted to stress on the alert is to clarify that indeed it's not a European blacklist. So the fact that someone is on the alert because got prohibited in one member state does not mean that this person would not be able to work in another. It's always, as Geraldine also stressed and all the other panelists, this is basically a decision of national authorities. The fact that you receive a warning from the other member state does not necessarily have any consequence in your member state, but you can be reassured that you were aware of this decision in the other member state and you can make your own decisions. So it was a very interesting takeaway for us, and there are certain issues where, especially technically, but also conceptually, that I think we can think about more, and also to be sure that the information which we discuss in our expert group actually reaches the competent authorities.
Andres, thank you very much indeed. And thank you also to the panel and to you for your contributions to that session. It's been very useful. We're now moving to the final part of the day. The next speaker is Zoltan Magyar from the Single Market Service Centre of DG Growth. As you know, he runs the Internal Market Information System and has been listening to your suggestions as well about it. We will look ahead and hear how his plans for development are going. Zoltan.
Yeah, well, where shall I start? Well, I prepared a presentation. I will go through all the details, and I'll try to get you into the details of our recent improvements and what we have put in place in IMI and how we improved the system. But I would also like to reflect on a few points that in relation to the alert mechanism have been raised and that are partially in the system, partially in place, and that what could be improved. And actually, I also had some ideas when I was listening to you what else we could do. I think we could, and that's not going beyond the legal framework and the content of alerts, we could share better the information about the practices of authorities who are sending alerts. I believe that could be very useful to understand also from the recipient side what triggers an alert on the sender side, and that information about the practices to some extent could definitely be shared in IMI. There are many things though which we unfortunately cannot do because we are restricted by the legislation and by the data protection rules that are applicable. Into the alerts themselves we cannot put in more details really than what we do today. We can look at the possibilities to put them into certain categories. They are already categorized in two cases, administrative reasons and professional reasons. We can probably improve that a little bit, but still we cannot include the details of the sanctions, the details of the prohibition. We can nevertheless facilitate the communication in relation to alerts, and that is something that we are going to do and we have clearly in our plans. There was another thing which was raised and to which I wanted to come back, and that's the editing of alerts, and this way we could definitely reduce the number of alerts. No. I mean, if an alert is sent and when it is broadcast, as you heard and as we all heard, in certain countries it triggers actions from the recipient side. The authorities may actually take a decision or follow up on the alert. If we allow this limited, restricted, but very important content to be just edited at any point, then we would lose traceability of what has triggered a decision in the recipient side, what has triggered an action on the recipient side. So that's not something that we can easily do. We could, of course, allow for updating not critical information in the alert, but if there is a deadline or there is a concretely defined restriction period and that alert is changed into a permanent prohibition or sanction, it is utmost important for the alerted authorities to be informed about this change. And if we just allow for editing and updating the information, that would not be transparent and could not be made transparent. It's also a question of at what point do you allow for an update, or would you let them just do it immediately or something. What we saw in practice happening in many cases, and that's very interesting to see, is that the alerts were created, were broadcast, and 5 minutes later withdrawn because the data was not correct that has been entered. And this happened systematically, and this created a significant number of alerts. I can tell you there are hundreds of alerts like this. There is one little thing that the competent authorities should actually do when triggering a large number of alerts, to pay attention to what is broadcast. And it's not automatic. The alert is first saved as a draft in IMI. You have to press 1 and eventually, depending on your role, 2 buttons to get this broadcast. If you have to withdraw it immediately 5 minutes later because that is sent by mistake or the data was not correct, then that's a mistake on the authority side. So in addition to what I said, I kindly invite the authorities to revise their practices in that sense as well. Yes, there is a time limit. Yes, the directive speaks about 3 days, and yes, there could be a large number of alerts to be sent, but the authorities must pay attention to what they are broadcasting. Otherwise, they are polluting the mailbox of other authorities and in general the system. It's also, there are some aspects on the searches and on the display of alerts in IMI, but as we go through, and now I turn more to the positive side about the improvements of the alert mechanism and the EPC procedure in IMI, you will see that there are things that are already in place, but probably we haven't advertised it sufficiently, or we haven't instructed sufficiently the member states how they can benefit from the functionalities that are available in the system. And definitely there are others which we further need to improve, and we will do that. That's a promise I can make. And let's see the details now. So I made a summary of the improvements that we recently put in place, just to indicate also how we took on board the comments that we have received from member states. And I do hope that some of these improvements also trigger new thoughts on your side, because there are changes in the system that we can easily make. Based on the feedback and on the initial immediate take-up of the alert mechanism, we have already reduced the number of emails that the system is sending, and we applied this rule of sending emails to functional mailboxes only in order to avoid that every single user of competent authority gets overloaded with alerts and that we have a large number of mailboxes blocked in Europe. So that has been put in place. The emails are sent to mailboxes, but more importantly, we also enrich the content of the emails. In the email, we included some data, and that you can see on this part of the screen as well, some data about the alerts. No personal data, but some detailed information. Most importantly, for the other health professions, you can always find the profession within the text of the email. You can also find the reason for sending the alerts, and there are this category A and B, the substantial reason for sending the alert related to the professional's exercise to practice, or B, administrative purposes. So that information in the email could already indicate to the authorities whether they should be looking at this alert or not, whether they need to pay attention or not, but that's a detail. If you believe that other information could be inserted in the email, and we cannot insert personal data, but other type of information we could, then you should just let us know, give us your feedback, channel it through your national IMI coordinator, and then we will do that kind of improvement without any problem. On several occasions already, since the alert mechanism is operational, we have enhanced the list of professions based on the feedback we received from the users. This is due to the fact that the professions are not regulated exactly the same way and with the same name in the different countries, and this concerns mainly the other health professions and the education of minors. When we inserted new professions or specializations that concern one country on another to make it clear that what is the profession which is sanctioned in this case. We improved the list of alerts in IMI. I will have a partial screenshot on the next slide, but I advise you also to have a look at it yourself if you are working with the alerts. And that list of alerts is available for exporting in the system. On this side, and there was a proposal previously about exporting the list and providing it for the member states, we have to apply strict data protection rules. We cannot just put things out from IMI and offer it to national systems to take it in, because then we wouldn't have any further control on what this data and what this information is used for. But the IMI users, the users of the competent authorities, can run a search, can export the search result, and applying their internal data protection provisions, can make use of this exported list. That we have done based on the feedback we received. We improved this list, and that actually, if you search within the module, includes the name of the professional, if that is visible to you, and the birth date of the professional. So if it was the proposer from the Netherlands, they want to do this check with a list, the list is there. They just have to make good use of it. We also improved the search criteria, and a few days ago it has been even made more prominent on the screen. So if you haven't searched for alerts yesterday and the day before, then I advise you to have a look at the search criteria once again when you are back at home, because you could probably find some new things on that screen as well. The screenshots I was talking about, and you won't be able to read the details, but on the top I just have a extract of the list of alerts that are displayed in IMI. As I took this screenshot as a Commission user, I couldn't see any personal data, obviously, and there you see the stars in 3 columns. On the left part of the slide, you see the search criteria, which also allow for searching by name, which allow searching for alerts by statuses, which allow to search for alerts that concern only that were sent based on substantial reasons with an effect to the professional's practice. So if I would be a competent authority and would go into IMI and would want to see only the relevant alerts in the system, I would definitely set the criteria and tell the system what to display for me. I wouldn't want to see any alerts in the category for administrative reasons, so I would select the criteria for searching for substantial reasons. I would set the criteria that I only want to see broadcast alerts, because there is no point to look at closed or withdrawn alerts. And eventually I would be interested in one or another detail. But already if I set those 2 criteria, I tell you that in the module for nurses, when we are talking about more than 7,000 alerts, I think, these days, I wouldn't find more than 2,000, which is just more or less than 1/3 of this alert mechanism. I believe that from the Commission side, we also have to give some more detailed guidance of how to use this alert mechanism technically as well. You talked about legal guidance. Yes, that's for when to send an alert and when to do it. But on the technical side, that's something that we could and we should and we will improve and provide more details of how to use it, how to search, how to export the list, what one can do technically in IMI, even with the current functionality. But once the new improvements are taken on board, those will also need to be included. In this sense, and there was one last point on this where we will do an improvement, that's about the list of countries of birth of the professionals, where we will have to include the 3rd countries as well. That's currently information that's missing. the professionals' current alerts cannot be sent, or you can only choose other in this list, and then you cannot specify. That's something that will improve. But that I mentioned because that could also become a search criteria if you think, or if you would tell us that's important, or based on that you could limit the alerts to be displayed in IMI. Marek mentioned the access to personal data and the coordinators' easy access and what they can do. We cannot provide a system that just by default anybody who receives the alerts would automatically get access to personal data. But we did make a big change since the launch of the alert mechanism. We provide a button for the coordinators which with a single click allow them to access the personal data. They have to somehow declare responsibility for the alert that they receive, and that they can do now with a single click. Before, it was a search, as Marek explained, that they had to add themselves as recipients, but that's over. Now they can easily access the personal data with one single click. The issue of having specific alert modules for different professions keeps coming back on the table. That would definitely facilitate the work of authorities responsible for a specific profession, like dentists, pharmacists, eventually social workers, which are partially covered by the education of minor and partially by the health module. We are ready to move in that direction. But there is one very important condition for that. We have to be sure that the alert modules which are put in place are properly implemented in all member states. And that's not yet the case. There are one or another alert module where we still miss the proper implementation, and introducing additional complexity without getting the things clear would not be a wise decision from the Commission and would just create further problems. We have been keeping this on the table, and we continue discussing this issue with the group of coordinators, and I confirm again, we are ready to move in that direction, but there are some conditions. We are also looking at the possibility to simplify the broadcast of alerts by the alert coordinators and provide solutions to obtain information from the sending country. That is something that I can tell you we will work on this summer. Hopefully after the summer break you could get an easy way to communicate and to send a request from the alert. I just wanted to warn the competent authorities sending the alert that this may result in a large number of information requests that they will receive. If many authorities will be interested on the background of the alert, that could easily also result in an additional administrative task for the senders of alerts. So if you know that the alerts are automatically sent to all countries, if half of them will ask a question about the alert, that will mean a certain number of questions. We will work on it, but in this sense, I would also like to give you a homework and some tasks to reflect on. I would like to know from you, and please channel this feedback back through your national coordinators to us. What are the questions that you would like to ask, or your competent authorities, the competent authorities of your member states would need to ask or would like to ask about an alert that they receive? Try to structure these questions or put them into a question-answer format somehow, because that will help us to create the relevant form and the relevant procedure in IMI to obtain further information on the alerts. That was about the alerts, and now the EPC improvements. And many of these, I hope, will be very welcome by you or by your competent authorities, even more by the professionals. We have already put in place a copy functionality for the professionals, which allow them to easily create new applications in case their application was closed or if they would like to apply for an EPC for 2 countries. This is something that probably your assistance centers will have to explain or will need to explain to the professionals as well, or something that we should also highlight on the Your Europe pages, that from within the application with the copy functionality, the professional can easily recreate his application or submit a new one for another country. We have improved the highlighting of fields and mistakes that professionals may make, and we completely prevent the submission of EPC applications to host countries where the professional is not regulated. We improved this on the professionals interface. Well, that is probably the most important improvement that we just put in place, and it was last Thursday, if I recall correctly, at 5 o'clock or something like that. Since then, the professionals, when submitting their applications, are clearly reminded of all the document requirements that can be requested from them. This includes all the details that are in the IMI repository, whether translations are required, whether certified copies are required, and what are the documents that they must include in the application when submitting. This is a lot different what there was before, because previously they were just asked to go back to the Your Europe page and check what they have to attach. No, they are presented with the fees, and they are presented with the list of document requirements up front before attaching any document. We'll follow this improvement closely. We'll see how it impacts the applications. With this regards, we also invite you to give us feedback from now on, whether you receive more complete applications from the professionals or whether further steps should be taken. As I said in the morning or before the lunch break, it will always be impossible to control fully what the professionals do when submitting the application, but we can do things and we can improve things, and by informing them clearly of what they have to attach, I think we took a big step forward. On the authorities side, we already managed to release some further improvements. We have now also beta tested with some coordinators this functionality, put in place a monitoring view for EPC applications, so the IMI coordinators of your member states can provide further feedback to the competent authorities and follow up closely the EPC applications. This monitoring view has just been released. It doesn't give access to personal details or the possibility to download the documents, but it allows for a close follow-up of EPC applications and to address problems, if any, in the process. The list of attachments is also better displayed now in the system with more information of when and what, at what time and by whom the attachments were modified, updated, or added. That is now visible. Those authorities who are dealing with the EPC applications will see it in the system. And we also made some changes in the procedure or in the technicalities of handling EPC applications to address the possibility of or the need for rejecting applications. Some of you may recall that it was not possible after a certain point, and no, if it's within the legal provisions of the directive or if it's in line with them, then with the justification this is possible. The temporary revoking or practically a suspension of an EPC application is also made possible for all procedures with the view of reactivating these temporary revoked EPC applications. In the process, those are the biggest changes, and we have also, and I didn't prepare this slide just after your interventions, but you may see some of this input already on my slide as well. So we are on the same track. We have some foreseen improvements in order to address the problem of incomplete EPC applications transmitted to the host member states. We are going to develop a functionality for sending information requests directly from the EPC applications, and we will try to display better the information about the authorities that are handling the EPC application. That's where we are, that's where we are going and where we are moving. I just want to recall the homework that I've given to you, and that applies also to this EPC improvements. Please reflect further on what are the actual type of questions or information that you would like to ask from the senders of alerts, but also in case of EPC from the other authorities in the member states. This question, or making it easy to send requests or to improve the communication between the one authority and the other country, came up with regards to the alerts, came up with regards to the EPC applications. Technically, we'll work on it, we'll put that in place. It's relatively soon, and for the alerts, I said that probably after the summer you will have it already in place, but we need to know what content to put into these information exchanges and how we can structure it better to your needs and to the needs of the authorities. So please come back to us with input on this side. Your national IMI coordinators will be there to assist you in this process, and we welcome all your feedback as we did so far. Being on the same track, I hope we are moving in the good direction, and after a year from now we'll reflect further on what else can we improve and how we can make it work better, because it's for our common objective. Thank you very much.
Zoltan, thank you. Thank you to the panel also for sitting there and finishing your work. It was great, thank you. And to everyone for your contributions for today. I hope the day has been enjoyable as well as useful for you and useful for the Commission too. And I hope you have every success with the EPC and also with the alert mechanism. Safe onward journey. Now for our closing remarks and thoughts for the future, let's welcome Hubert Gams, who is Director of Modernisation of the Single Market DG Growth. Hubert.
Good afternoon, ladies and gentlemen, dear colleagues, dear participants in this workshop. I think, and I hope you share this feeling, that we had here an interesting workshop full with fruitful and interesting exchanges, and that's thanks to you. I want to thank particularly, of course, all the speakers for their, may they come from professional associations, from national authorities, from the commissions, for their very valuable contributions. And I also would like to use this opportunity, of course, to thank our moderator, Diana, for her excellent job that you did, and of course all the participants, you all who have contributed and who have made these discussions a success, certainly from the Commission perspective, because this was an opportunity also for us to learn a lot. Therefore, I consider that the objectives that we had for this workshop have been well achieved. Not only did we manage to raise more awareness about the European Professional Card, the EPC, and about the alert mechanism, which is of course closely linked to it, but I think this has been an excellent forum to exchange experience of the first year, a bit more than a year actually, from both sides of the national authorities, and very importantly to hear also from the professions. These exchanges are very valuable for the Commission, because we trust that, and we hope also, we trust that it's also the same for the many stakeholders in this area that are involved with this initiative of the European Professional Card. Because these exchanges help us achieving our common goal to implement this initiative in the best and most user-friendly way that is possible. And so I'd like to use this opportunity of closing this workshop to revisit some of the outcomes of the discussions that we had here today. I'd like to stress how impressed and reassured we are that the EPC has been taken up across the EU well beyond what we expected. Irmfried and Martin already provided you with the figures, but it is important to highlight again that within a bit more than a year, not only did we have more than 2,500 EPC applications and more than 1,000 European professional cards that were issued. I think these numbers are impressive. These statistics prove that the EPC is an appreciated tool to facilitate the professional recognition procedures, and if we all together implement them well in practice, that they serve greatly both the professionals and the authorities, and ultimately, of course, the citizens. And the numbers also confirm the choice that we have made together with the relevant stakeholders, you, for the initial 5 professions: general care nurses, pharmacists, physiotherapists, real estate agents, and mountain bikes that benefit from the European professional card. The first panel this morning looked at conceptual challenges of the EPC and how these could be accommodated. Danielle from Malta, Gloria from Spain, and Heinrich from Germany explained their national contexts and approaches in this regard. These views were interestingly contrasted and discussed all together with the views from the professional organizations that they were expressing. Roland shared some of these issues from the perspective of physiotherapists, and Alberto provided very useful input as regards the mountain guides. The second panel focused on more technical issues and was looking at how to improve the way the EPC operates. Luc explained the issues real estate agents are facing when they are submitting their EPC application. And in the context, we talked about the online simulator that, of course, should help professionals to consult the different document requirements and the fees in the different host member states. Senis from the Netherlands, Alexandru Ionut from Romania, and Sarah from the UK, as well as Katja from Finland, provided us with very practical and constructive approaches on how member states deal with the document requirements and document validation and authentication. And we could all pick up, I think, very interesting approaches and ideas from these contributions. And similarly, of course, from the interactive exchanges that involved you, the audience. And I hope very much that this will provide food for thought for all of us, and in particular, of course, the public authorities, how to further improve the day-to-day handling of EPC applications. They also have shown us where we can develop the EPC procedures further on technical terms to make them more user-friendly. The third panel focused on the functioning of the alert mechanism, a rapid and proactive warning system that is also based on the internal market information system. And I would like to use this opportunity to reassure you again that the patient and consumer safety is of utmost importance to the European Commission, as much as it is certainly for all of you. And that is why our approach was and remains to ensure the balance, providing that patients and consumers are well protected while we all together try to facilitate professional mobility. During the panel discussion, Geraldine from Ireland, Tatiana from Denmark, and Marek from Poland explained certain issues, both challenges and opportunities their authorities were facing when implementing the alert mechanism. Nicola, representing the Health Professionals Crossing Borders initiative, could provide us with a more horizontal views of the health authorities across the EU. And it was also very interesting to listen to Sarada and to learn about the views of medical doctors, who could also be the subject of alerts if they got restricted or prohibited in their home member state. I think all speakers appreciated that the alert mechanism established swifter, secure, and efficient communication channels between the competent authorities and further strengthened the mutual trust a key element, the mutual trust between authorities. Nevertheless, we also have to appreciate the challenges regarding the difficulties of the implementation of this mechanism due to the different national, disciplinary, and professional rules. We are very much committed to continue the discussions, similar to the one today, that can build a better understanding on what kind of national decisions are behind the alerts that the national authorities are sending to their respective counterparts. This is especially important in this context, given the high volume of alerts. Altogether, more than 13,000 alerts were sent just in 14 months. We are committed to provide all legal and technical support that we can provide, support to national authorities to ensure that the alert mechanisms are working according to the objective. We do not want a single market which is abused by unreliable professionals that put our citizens in danger. To conclude, the EU and the single market need to adapt to a changing environment and need to keep, at the same time, up to date. Innovative ideas and better use of electronic procedures must find their place. And both the European Professional Card and the alert mechanism certainly have found their place. Last year, during the launch conference of the EPC and the alert mechanism on the 18th of March 2016, my colleagues already stressed our commitment to closely monitor and evaluate the use of these two policy tools, including the consultation of all relevant stakeholders. I think our workshop today was an important part of this process. Nevertheless, from our side, of course, the evaluation and the monitoring of this initiative is a continuous element. We have to continue to do it. There were several expert meetings, a conference, and a big number of bilateral exchanges are behind us, and they've all contributed to ensuring the initiatives are implemented in the most reasonable and effective way. Andras previously told you about our recent survey carried out to gather your views on concrete issues related to the EPC and to the alert mechanism. We are very grateful to the 181 competent authorities and professional organizations that took the time to reply to this survey. Also, a number of position papers were submitted offline during this consultation period. We're also grateful for them. The results of this survey will be duly published, as well as the responses provided, to the extent that the respondents will have agreed to publicly disclose, of course, their contributions. On the basis of your contributions, we will update you later this year on the assessment, on our assessment regarding the first year of the operation of the EPC and of the alert mechanism initiatives. Nevertheless, it is very clear to me that we need to continue working together to face the challenges and to seize the opportunities ahead of us. This is the key to unlock the full potential and the full benefits of both the EPC and the alert mechanism. Your views continue to be very valuable to us in further improving the functioning of these new single market tools. And Zoltán explained you some of the technical IMI developments that we have already introduced and others which are in the pipeline to make the system work better, even better. And these improvements are thanks to your constructive inputs and suggestions. We are therefore committed to continue fine-tuning within the existing frameworks, the EPC procedures, and the relevant IMI functionalities in order to further improve the way they work, the way they function. And the constructive exchanges we had today certainly contributes to exactly these objectives. Thank you very much for your active participation today. Bye-bye.
For me like a ghost, you dress pulled out from catching at your